Attendance is running. Okay, welcome everyone. First, some technology news that I think you will like very much. You should all see in the upper left-hand corner of the screen it says recording. And next to that says live on Otter.ai live notes. Click that, and there's a little arrow. It says view view stream on Otter live notes. Click that. We now have a live transcript of the class. Every word I say and you say will be transcribed in real time. And it gets even cooler. I can actually enable closed captions right in Zoom. So everything I say is transcribed in real time. It gets even better. At the end of class, you can download this entire file in your notes. Oh, God. My beloved Comcast people are doing work in my neighborhood today, and my connection dropped before. So if my connection drops, it's because I'm on my hotspot. So I apologize in advance. It gets even cooler. You can actually jump to a specific point and play the audio from that point for whatever you're looking at. So it's really, really, really cool. I'm pretty sure I'm the first person in the building to use this. I've been looking into this now for some time. I finally got it working yesterday. I did it myself. I paid it myself. So no one else will have this yet, but I'm going to recommend this. The upshot of this is you don't need to sit there taking verbatim notes, which is never a good thing to do. I think people are wasting their time when they type everything verbatim, right? It's not a good use of your resources. But what this will allow you to do is pay attention more closely, and you can always supplement your notes later. Now, I don't know how I'm going to do this, but I'm going to try. I'm not making a promise, but I'm going to try to somehow do this for your first 19 classes. I don't know how. I think I can figure out how to do it, but I'm going to try to transcribe the other ones. So in theory, at least, you'll be able to have your entire semester transcribed. I can't promise I think I can do it, but I'm going to try. And that's best I can do. If you want to see what this looks like, let me copy the link for my property chat that I just finished. This is from my property class a minute ago. And what you actually have is the entire class transcribed with different speakers. So you can tell when I'm speaking versus when a student's speaking. And you can jump to a specific point in time to play that. Yeah, no, I know. This is not going to be popular with everyone. I know I'm going to make a lot of my colleagues mad at me. This is usually what I do. But I'm very excited about this because I don't want you sitting here typing everything verbatim. All right. So you can access the. I have to figure the best way of doing this. I'm not quite sure yet, but you can access this one by clicking the Otter Live Notes link, and I'll bring it up right away. And what I'll do is I'll put it in the class chat for today. That way you can easily find it. I'm still tinkering with this. I don't quite know the best way of doing this, but it's pretty game changing for notes. I know some professors have a thing where they let one student transcribe the entire class as like a transcriber. Well, this is the computer's doing it for you, so it's all transcribed and it's not perfect. Someone said court reporters we put out of business. Not quite. It's like maybe 90% accurate, which is I think pretty good, but it's not 100%. So
all right, Let's get started.
Oops, who's that? Is that me?
Okay. Let me turn on the live stream for a moment.
Oh, I know what happened. That's me. Oh, you're hearing me from my other class. I see what's happening.
All right. Welcome back, everyone.
Well, I was playing myself. That was a little trippy. Okay. All right. All right. So any questions not about the transcript, about the actual class? No? All right. The attendance should be running, and hopefully you have that. And let's begin by recapping from our last class. We've introduced this new topic about the due process clause, right? We previously studied the privileges or immunities clause in Slaughterhouse. And we previously studied the equal protection clause in cases like Plessy and Yik Wo. But our next topic is on the due process clause. And this is a topic that we'll spend a lot of time on. I mean, just weeks, the rest of the semester, basically. And I want to do a few questions to begin. And the first is I want to distinguish between two different kinds of due process cases. One which we'll study at great length, and one I'll probably never mention again, but I want you to at least understand it. So let's start with a short answer question. I want you all to do your best to define in a sentence substantive due process. This is not easy. Professors can spend an entire book on this question, but I want to see if you can drill it down to a single rule statement, just one sentence, see how you guys fare. All right, see how you do. This one's a little harder, I know. And by the way, with the Americans with Disabilities Act, not to be too harsh, I think schools are actually required to have live captions. I think we're just completely out of compliance with the law. I don't think it's even a close call. For students with disabilities, this is actually, I think, required by law. So I think I'm okay complying with it. Some schools, I know, will not let you have an online class unless there's a caption. And historically, this was so expensive it couldn't be done. But now it's done automatically on the fly. It's not perfect, but I think it's pretty good. Anyway, I'll email the dean later just to flag this. I'm going to try to transcribe the rest of the semester. I can't promise it because it's I don't know if it'll work, but I'm going to at least I'll make an effort to research it. It doesn't look easy, but I think I can upload all the old YouTube videos, which might take a while because they're like 4 gigs each. They're huge, and Comcast will kill me, but I'll try. Okay, all right. Who's next on the list? Who's up first?
That should be me, Professor. This is Sam speaking.
Oh, Sam, thanks so much. All right, so Sam, let's start just with very basics, right? What do I mean when I say substantive? This was a question someone asked me last class. No, it was a good question. I want to make sure you understand this. What does substantive mean in this context? Forget due process, just substantive.
I believe you were mentioning that it's the content.
The content of what?
Of the procedure.
The content of what?
So, the right that's being protected, that it's... trying to explain that, like you're saying, it's a little difficult to split from procedure and substance, but it's a person's personal rights that are so protected under the Bill of Rights.
Okay, that's good, Samuel. I appreciate it. Let me just pause here. I'll go to who's next? I'll go to you in a minute. Whoever's next. I have to bring up my roster. It's Stuart. I'll go to Stuart in a minute. But that's good. Thanks, Samuel. So when we talk about the due process clause, right? When we talk about the due process clause, we're talking about two different concepts, right? And look at the text of the due process clause, right? It says, nor shall any state deprive any person of life, liberty, or process without due process of law, right? When we think of the word substantive due process, what we're really thinking about is, what does this word liberty mean, right? What is the meaning of the word liberty? What is the content of the word liberty? That's what rights fall in that word. What is the substance of liberty? What does liberty include? The right of contract, the right to direct the upbringing of your children, the right to send your kids to school, the right to marry, the right to access an abortion, the right to access contraception, the right to engage in sexual relations, right? What is the substance of the word liberty? That is the question of substantive due process. If I had to sort of distill it down to a single sentence, right? Substantive due process is asking, what is the substance or the meaning of this guarantee of liberty? And once you know what that liberty is, then the courts can assess if the state can burden that liberty, right? Just because you have a right doesn't mean it's absolute, right? This is the thing that students have difficulty getting. Just because there's some liberty interest doesn't mean it's 100% in all cases prevails. In some cases, a state may have a strong enough interest to burden it. Maybe yes, maybe no. What the courts do in substantive due process cases is they ask first, is there some sort of liberty interest at stake? Is there some liberty interest that's protected? And second, does the state have a good enough reason to violate it? If the state has a really good reason, they can do it. If the state doesn't, then they can't. Think of Korematsu as an example. It's not a perfect example, but it's an example. There, the government was locking people up in camps. Actually, they were excluding people, to be precise, in Korematsu. And the court said they have a good enough reason to exclude people, even though their rights are being deprived. Okay, that's substantive due process. The second branch, which I won't even return to, is procedural due process, which sounds kind of like redundant. Procedural due process asks, what are the various processes given before a right can be taken away? So let's say you have, some license from the government. I don't know, let's use an example you're familiar with. A law license, right? Let's say you're barred by the state of Texas with a law license. And let's say the state wants to deprive you of that license. They want to take away your law license. Hopefully it never happens to any of you, but it happens every year. In order for the state to deprive you of your law license, they need to give you certain processes. For example, they need to give you a notice, right? Why are we taking away your license? They have to give you an opportunity to be heard, right? You have to have a public hearing. It can't be done in secret. They can't, quietly take away your license. There has to be some kind of appeal, that if you don't like the initial ruling, you can appeal it, right? There are different facets of due process that apply to any sort of case where the government's taking away your property or your rights. I don't have time to teach you about procedural due process. It's an entire area of the law. We'll be focusing on the substantive component, but just know that these two elements exist. All right, does that clear up maybe a little bit the different standards for the different kinds of due process? Yeah? Any questions on that? Okay. Let's do a review of Lochner, which is the case we did last week, or last class. Question number 2. Which opinion in Lochner placed the burden of proof on the government? This one's for Stuart in about 10 seconds. All right, Stuart, you here?
Yeah, I'm here.
All right, Stuart. What is your answer, my friend?
I'm going to say Justice Peckham.
Okay, why do you say Justice Peckham?
Process elimination. Saying
That's actually fair. It's a fair thing to do. Process elimination. So explain your reasoning.
Well, Justice Harlan, he was saying that people who bring forth arguments that something's unconstitutional bear the burden of proof.
Okay. But Stuart, let's take a step back. What do I mean by burden of proof? What is a burden of proof? What does that phrase mean? I kind of use it, but what does that mean?
You have to show, beyond a reasonable doubt that something. I hate when I get this question. You have to show that something is beyond a reasonable doubt that, for example, something's unconstitutional. You have to show beyond a reasonable doubt it's unconstitutional.
You keep saying beyond a reasonable doubt. We're getting the standard from beyond a reasonable doubt. Where's that standard come from? Where have you heard that before?
Trial cases.
What kind of trial cases?
Criminal cases.
Is the standard in a civil case proof beyond a reasonable doubt?
I guess it could be, depending on the case.
Not quite. Tori, you here?
Hey, I'm here.
Tori, where have you heard this phrase proof beyond a reasonable doubt before?
Yeah, it's in criminal trials.
Is that the standard for civil trials also?
No, for civil trials, it's preponderance of the evidence.
Yeah, preponderance of the evidence. But Tori, more basic standard. What does burden of proof mean? Just more generally.
Burden of proof is you are the one that has to bring forth the evidence to prove your case. I understand that's like on both sides, so that's pretty general. But
right. So in a criminal case, who has a burden of proof at all points?
The prosecutor.
Does the defendant have any burden at all?
Not necessarily.
Can the defendant walk into court and say, "Your Honor, I have no case. I rest"? Can they do that?
Uh-huh.
Does the defendant have to testify on his own behalf or put any witnesses on his own behalf?
Nope.
Okay. You're right. In a criminal case, the defendant can just sit there and say nothing, and that's perfectly fine. It's all in the government. They have the burden of proof to show beyond a reasonable doubt that the defendant convicted the crime. So, Tori, in a civil case, who has a burden of proof?
The party bringing the case.
The plaintiff, right? And does the defendant have any burden of proof in a civil case?
No.
No, the burden belongs to the plaintiff. And you said the standard, but what's the standard called for civil jury trials usually?
Preponderance of the evidence?
Exactly. Thanks so much, Tori. Yeah. I don't want to give a number because it's wrong, but preponderance is more than 50%. That's usually how you set like 51%. It's not a perfect standard, but it's more than that. Beyond a reasonable doubt, I won't say 99% because I'm not supposed to say that, but it's very high, right? You have to be very, very damn sure that the defendant committed the crime, right? It's a much harder burden of proof. But you don't think about burdens of proof in constitutional law, but they're really important. In constitutional law, generally, whoever has the burden of proof is going to lose. If you're the government and you have the burden to defend your law, you're probably going to lose. If you are the plaintiff and you have the burden of proof, you're probably going to lose. The most important, not say the most, but one of the most important questions in constitutional law is who gets the burden? How does the court allocate the burden? In some cases, the challenger, the plaintiff, has the burden of proof. And in some cases, the defendant, the government, has a burden of proof. Now, how do you decide who has a burden of proof? The Constitution is silent. It says nothing about any of this. This is all judge-made law. Lochner illustrates three very different approaches to the burdens of proof.
Class, is it just me or did he freeze?
I think he froze.
I'm here. Do you not see me? I'm sorry. Ugh, God. Comcast.
Yeah, that's what makes it.
I'm back. I'm on my hotspot now. And you should be able to hear it. Can you guys hear me now? Okay, good.
You're good now.
Okay. All right. I apologize. Yeah, I told you Comcast is outside, doing their thing. So, all right. Is it closed captioning still running like before? Okay, good. Thank you. Now the good thing about the transcript is I can see exactly where it left off. Good. The three opinions in the Lochner case illustrate three different ways of allocating the burden of proof. And these are very important. Again, Lochner is not good law, but you have to understand each of the three different approaches. Okay? Oh, God. You guys back? I apologize. I saw the Comcast truck pull up this morning, and it's just like this symbol of just dread, because I know they're going to be doing crap to my internet. The three opinions in Lochner illustrate the three approaches to judging. The first approach that I want to talk about is Justice Peckham's majority opinion. Okay? The Justice Peckham majority opinion puts the burden of proof on the government. And it works like this. The government is burdening the rights of Joseph Lochner. It's not Joseph Lochner's job to attack the law. It's New York's job to defend the law. Why does this burden matter? Because New York must put forward evidence to show that their law is reasonable, right? The law makes sense. It's very hard to defend most laws because most laws are not very logical. They're passed because of coalitions and politics and things that aren't always reducible to a court proceeding. Okay? So the court proceedings very much favor Joseph Lochner under the Peckham majority approach, precisely because it's hard to show why you have a law. The Harlan dissent, the second approach, is very different. Justice Harlan would put the burden on the plaintiff, which follows the usual model of civil litigation, right? If you're the plaintiff, it's your burden to show the law is void. That's the plaintiff's burden. Therefore, the plaintiff must put forward evidence to show that the law is irrational. And if the plaintiff can show it's irrational, then the government has to, put forward some evidence to show why it's okay. But the burden belongs to the plaintiff, and then the defendant, the government, can basically rebut it. They can say, no, here's why we have this law. The third approach is by Justice Oliver Wendell Holmes. Just hearing about a lot of Justice Holmes this week. This is like the anti-Holmes week, I think, in class. Justice Holmes says this is ridiculous. The mere fact that the law was passed through the legislative process means it's reasonable. We don't need to assess evidence. We don't need to assess any sorts of balancing, right? When we're dealing with the due process clause, let's just assume the laws are constitutional. So really, there is no burden, right? The government has no burden. They can just walk into court and say, Your Honor, we passed this law. We think it's rational. We don't really have a reason for it, but we think it's a good law. You can give a reason if you like. We can make one up. That's fine. But we don't really have one. Okay. We rest. Imagine that you go into court and say, Your Honor, may it please the court, we rest. And you still win the case. That's basically what Holmes is suggesting. Even if the government walks to court and says nothing, they'd say, Your Honor, thank you very much. We think our law is rational. It can serve some purpose. We don't really know what it is, but there's probably one. That's good. Litigating on behalf of the government can be hard in Justice Peckham's world. Litigating on behalf of the government can be really easy in Justice Holmes's world. Right? If you're a government litigator, you love Holmes. Oh man, he's your boy, right? He's your guy. That's your key. If you're a plaintiff challenging an economic regulation, you love Justice Peckham. That's your home sweet home. How you allocate the burden matters. And in all the cases we study for the rest of the semester, we'll be talking about who gets the burden and what that burden is. All right. I can actually see what you guys were saying when I was out of the class. This is actually fun. Yeah, no, I turned the YouTube live stream off. I can't stream it. I'll upload the video later. I apologize. I'm recording it locally. Seriously, I saw the Comcast truck. I'm like, oh, not now, not now. Catherine, go ahead.
So would you say that Holmes really just cares about the procedure and not so much the substance?
I would absolutely say that. In fact, you have Buck v. Bell in your reading for today. I think Holmes makes that point very, very well in Buck v. Bell. Holmes is not interested in this substantive approach. That phrase didn't exist, but he's not interested in saying what rights protect him. In his mind, the 14th Amendment should not be read to protect all these newfound, funny rights. Right? Courts are not in the business of second-guessing the legislature. Holmes was at base what you call a model of judicial restraint, if you want to use that phrase. It's a loaded phrase, but that was his approach. Holmes once wrote a famous letter to a colleague, and he wrote something like, if my fellow citizens want to go to hell, I will help them get there. I'm paraphrasing. If my fellow citizens want to go to hell, I will help them get there. His goal was to help the legislative process go where it wanted to go. He didn't want to stop them. And later in his career, he had sort of different views on free speech that became very famous. But at this time in his career, in the early 1900s, Holmes was, let's just do whatever the government says. This is not for us to intervene. As long as they're following the process, they're giving a jury trial, they're giving, a proceeding. Lochner had a judge, everything was fine. We're good. Catherine, does that answer your question?
Yes, thank you.
Yeah, Tori, go ahead.
Just real quick, I have in my notes that the Holmes dissent, like that view of the burden of proof and whatnot, is the current lens that a lot of Supreme Court justices use these days. Is that correct?
Yes.
Okay.
We'll go into this more next week, but the Holmes opinion is the test for certain economic cases. Other rights are not. For example, abortion and intimate relations are not reviewed by the Justice Holmes standard. But in due process cases involving property rights and contract rights, today, Holmes is the word. They don't cite Holmes, but it's Holmes. There's another case that cites Holmes. They cite that case, but it's basically Holmes. Yeah, I mean, he's influential. Most justices in the early 1900s are pretty insignificant. Who the hell knows who Justice Rufus Peckham is, right? Harlan is well known, but the Holmes opinion still has juice. Okay, Macy, go ahead.
So if we were going to talk about the Holmes opinion for present day, would you want us to cite Holmes in Lochner, or would you want us to wait and cite the other case that we haven't gotten to?
Ask me next week. You'll see which case you're supposed to cite. It's just you're a little bit premature. We'll get there, I promise.
Okay. thank you.
I don't want to go too far ahead because I'll lose people. Someone asked if Justice Kagan took the Holmes approach in the CFPB case, seal of law. I think we should just be careful here, right? When we're talking about Holmes, we're talking about the due process clause, right? That's the second half of the semester. The first half of the semester on the structural cases is different. But if your question is more broad, if we're talking about deferring to the democratic process, then absolutely Holmes and Kagan were on the same page. In fact, in Myers versus United States, this was the postmaster case. Justice Holmes dissented. And he said if Congress wants to limit the president's removal power, then they should be allowed to do it. So even to this question, Holmes did have also a narrow view of the separation of powers. He said, let Congress do what it wants. If they want to constrain the president, so be it. Who are we to decide? All right. Questions on Lochner. Very important case. Again, most law professors will teach you that Lochner is the most evil thing in the world. I won't teach you that. I don't think it is. You can agree with the majority or the dissent. I don't really care. But it's an important case to teach you the different ways of which courts approach due process cases. All right. Let's move on to today's material. Last class, we were talking about economic cases. How many hours can a baker work? How many hours can a woman work in a laundromat? What wages can be paid to, women workers? Can people restrict the sale of property based on race? Right? These were all economic cases. Today, the courts draw a sharp distinction between due process cases involving economic rights and due process cases concerning personal rights. This was actually Macy's question from a minute ago. I'm sort of hinting at it, right? Today, economic liberty cases involving economic and property rights, are still governed by Justice Holmes's approach. But due process cases based on so-called personal liberty don't follow the Holmes approach. Due process cases concerning personal liberty are probably closer to the Harlan model, or in some cases even the Peckham model. We'll go back and forth. We'll discuss those two. Now, you may ask, what's the difference, Josh, between economic liberty and personal liberty? Well, the Constitution says nothing. It just says liberty. You don't know what the hell it is. But in the modern era, economic rights are considered not very important. Personal rights are considered important. We have cases involving gay marriage, and cases involving abortion, cases involving, an entire list of things that might be considered personal, right? During the early 20th century, there was no difference, though. There was no difference between economic and personal rights. There was no difference. The court approached, the right to contract in Lochner the same way it approached the right to direct the upbringing of your children in Myers. The court approached, the right to, sell your property the same way they approached, the rights to, send your kids to a private school, for example. The courts did not draw a distinction between economic and personal liberty. You should, because it matters much more after the 1940s. It makes a huge difference. But at least in the earliest 20th century, it made no difference. And that's my transition to the three cases for today. Myers against Nebraska. Actually, it's Meyer, it's singular. There's no S. Meyer v. Nebraska. Pierce versus Society of the Sisters. And perhaps one of the most infamous cases of the semester is Buck v. Bell. I told you guys we have some rough cases this semester. They don't get easier. They get pretty bad. These cases were not involving economic rights to contract, how many hours you can work, what your wages are, right? You're not negotiating over labor contracts. These were the state restricting personal relations. Okay? And in each case, I want you to keep a question in mind. What is the state's interest here, right? Why is the state restricting this right? What is their goal? What are they trying to achieve? Right? Why is the state doing this? And once you know why the state's doing it, you ask a second question. How are they doing it, right? In other words, what means are selected to accomplish a certain ends, right? What are the ends? What is government trying to achieve? And what are the means selected to achieve that goal? Okay. So let's try then the first case. Go to question number 3. This is a short answer, so I want you guys to think a little bit. What is the state's interest to prohibit the teaching of certain foreign languages? This is the issue in Meyer, right? What is the state's interest to prohibit the teaching of certain foreign languages? Okay. All right, another 20 seconds, and I think who's next? I think who's next? I'm at 15 seconds. Okay. All right, Husna, help us out here. What is the state's interest to prohibit the teaching of foreign languages, or certain foreign languages? Not all foreign languages, but at least certain foreign languages.
Can you hear me, Professor?
Yeah, loud and clear. Thank you. I can hear you, and I can see your words written on the screens. It's amazing. It's magic.
All right, perfect. Okay, so I was saying, basically, the state was doing this to promote the public interest, like make children, like, okay, I know this sounds weird, but like make them American at heart.
You're allowed to say that. You can say that.
Yeah. So basically, it was so that they grow into the English language. It becomes a part of them because they considered that if they learn a foreign language, those specific ones, like they would be more connected to their native land.
Okay, so let me ask you the follow-up question. Why is the state trying to make these children more connected to America and less connected to their home country? What's their interest here?
Because they're American citizens, so they want, like, I believe it was saying that there's a lot of fear of like children like being connected to a foreign
Right.
nation.
Why are they afraid of that? What's so bad about that?
Like, okay, maybe this is a stretch, but like if there's war or like things like that, like I'm thinking of like korematsu and stuff like that, like implications like that.
Yeah, it's kind of ugly, right?
Yeah.
Thank you, and I appreciate the answer. So let me give you guys some background, right? This case, Meyer v. Nebraska, arose, what was it, 1924? Damn it, off by a year, 23. That's close. What was going on in the world in 1923? Well, we had just finished World War I, right, a couple years earlier. What wasn't called World War I, it's called the Great War. Really know that because there was no World War II. It was called the Great War. The Great War had just finished. And, the United States had engaged in this bloody, bloody, awful battle in Germany, in France, and on the continent. And as often happens during war, hostility forms against the country you're fighting. It happens anytime there's any sort of conflict. And we were fighting Germany. And unsurprisingly, there was a lot of hostility towards Germans. This may sound shocking, but people did not want Americans speaking German because they thought they'd be spies, right? They thought they would have a loyalty to the homeland. I think Husta mentioned the Korematsu case. I think it's a very good analogy. The same sort of, I shouldn't say the same, but a similar type of hostility towards Germans existed later towards the Japanese people. So this was a law designed to perhaps promote assimilation and to prevent people having foreign ties. Because they weren't banning all languages, right? Some languages were okay. For example, the so-called ancient languages like Latin, Greek, and Hebrew were fine. But what they called alien speech, German, French, Spanish, Italian, etc., were prohibited. And to be frank, these were predominantly immigrant tongues, right? The immigrant community would speak these languages. Okay? So the state's interest was to promote assimilation and promote, a common tongue. By the way, the word tongue is a synonym for language. It's like a weird word, but it means language. All right. Now try the second question. I asked you the first one. What is the state's interest? The interest of promoting assimilation. The second question is also very important, right? How does the prohibition of teaching the foreign language accomplish that state interest? Excuse me. Okay, this one's going to be for Benjamin in about 20 seconds. Or maybe make it 30 seconds. Okay. Benjamin, you here? I'm sorry, Jeffrey. Oh. Benjamin. Yeah, sorry. I know who you are. We hung out this past weekend. Let me ask you this question. How does the prohibition of teaching the foreign languages accomplish the state's interest?
Well, the short answer, I would say that it doesn't.
Okay. So why?
They were. The state's position is that they would be focusing more on learning the English language and being, coming out better American.
Well, why? You said it doesn't. I want to focus on the first thing you said, please.
It doesn't.
You said it doesn't. Why? Wait, if you ban the teaching of foreign languages, does that mean they'll not learn these foreign tongues? How does the policy not accomplish the state's interest?
Well, because they're still able to learn other languages, therefore they're not investing any more time in the learning of English.
Yeah, but there's no nation state that speaks Latin, right? There's no enemy nation that's speaking Greek. There's no enemy state that's speaking Hebrew.
I don't really think that matters, though. If your focus is not on one particular thing, whatever it is that's drawing your focus away from it is irrelevant. It's not being focused on the one thing that they feel like you need to be improving on.
Huh. So you're saying even on its own terms, the government's not accomplishing what it says it's going to accomplish?
Yes, sir.
And you know that because they're only banning some languages and not others. That if they were really interested in promoting assimilation, they would ban all languages. So you think a better statute would just ban all foreign languages and that would be better. Would that be okay?
I wouldn't say it'd be okay, but that would accomplish their goal.
Okay, very good. That's good, Benjamin. Let's try next on the list. Is Lewis here? You here, Lewis?
Yeah.
So, Lewis, in your mind, does the prohibition actually accomplish the state's interest?
I don't think it accomplishes the state's interest.
Okay, why not?
Because I believe in the case it mentioned somewhere that if these children were speaking the languages at home, just speaking English in class isn't going to help them assimilate because their home language, they're still being spoken to in German, Italian.
So then maybe the state should have mandated they speak English at home only. Can they do that? So would that be better?
No.
Well, why not? Just put a mandate. You can't speak foreign languages in the state anywhere. If you have to wear a mask, you have to speak English everywhere. What's wrong with that?
Well, I mean, they don't have the power.
Sure, they do. They can have inspectors, child inspectors, every home. Make sure we speak English.
Happening in your home.
Why not? Why not? If the state has an interest in bringing assimilation, why can't they?
I mean, I think that's a pretty overarching interest if they're trying to
control
how you
look. If speaking a foreign language is so dangerous, we should be able to inspect it. If parents are abusing their children, why can't we send child inspection teams to their homes to see what language they're speaking? If this is abuse, we should stop it.
Well, so their big claim of assimilating is based on like public safety because of I guess previous wars.
Yeah, we can't have this.
So,
we can't have these kids speaking German.
I don't know. And it talks about the means were prohibited. So their way of going about it is not like constitutional. They can't go about it by just outlawing all other languages. And I don't know.
Chris, you here?
Yeah.
Oh boy, you're choppy. I'm sorry, and I not want to speak today.
Can you hear me?
Yeah, it's very choppy. We'll do our best. So, Chris, let me ask this question.
Okay.
Why can't the government, try to accomplish its goal with a less than perfect solution? In other words, maybe Benjamin's right. Maybe this is not a perfect solution, but why does the government need perfection? Can't they just address part of the problem and maybe deal with the rest of it later? Why can't they do this?
Well, I think that would kind of, you have to ask why government exists, right? Like, it's to offer solutions to essential problems that come with living in a collective, right? And so if there's a more optimal solution, then you could argue that they are obligated to follow that optimal solution. Yeah?
But why is the government obligated to make a perfect solution? Maybe they say, okay, well, in this statute, we'll regulate schools, and then tomorrow we'll pass another statute to regulate homes, right? And then maybe next time we'll have a statute regulating Greek and Latin, right? Why can't the state move in an incremental fashion to address part of the problem a little bit at a time? Why do they have to have a statute that addresses every facet of the issue right away?
Well, that's not really the problem, though. Like, you can address increments, but not at the expense of other.
Why not?
Or not at a substantial expense, right?
Why not?
Like, if you were to limit the language of particular households, you, I guess, on its face, kind of put a Band-Aid on it, and then you have at the expense children who aren't educated in multiple languages, which are proven to be an advantage in every situation.
No, but the state disagrees. The state sees no advantage. Are you saying the state's wrong? Did they not get deference? Are we required to listen to experts over the state? They're elected. They're accountable.
Well, we aren't required to necessarily agree with the state, right? And I think that there should be more deference placed upon experts in the subject rather than politicians.
But
The question here is the question here is the question posed in the state in the question number 4, right? Does this prohibition accomplish the state interest? And a lot of you, thanks, Chris. I'll move on. A lot of you are saying things like, "Well, it's not good enough, right? If it was really trying to promote assimilation, it would do this and this and this. It would also ban Greek and Latin." Now they're saying, it's too broad, right? The state shouldn't be able to do this. But how precise do we have to be, right? Why can't the state address a problem in a less than perfect way? Not perfect, right? It's not perfect. But why can't the state say, you know what, we think assimilation is a very important interest, and this is a reasonable way of accomplishing that goal? Justice Holmes seems to think that, right? Justice Holmes seems to think that this is reasonable. It's reasonable for the state to promote a common language. It's reasonable to prohibit teaching foreign languages so students are exposed to English and speak only English at school. Right? Maybe the state can't control what happens at home, but that's not for the state to decide. They can decide to tackle part of the problem and maybe address the rest of it later. Holmes says this is not arbitrary. He says this is an issue that people might disagree on. It's reasonable. Why can't the state experiment, Holmes says? Right? Why can't the state conduct this experiment to decide that this might be a way? If it doesn't work, they can repeal the statute, right? If this proves to be a disastrous policy, they can repeal it. Right? Dina, why is Holmes wrong here? Or is he wrong? Maybe Holmes is right, right? What are the shortcomings in Holmes here? I think you're on mute, Dina. I'm sorry. I don't hear you. It might be your ear pods if you want to take them out. This happens very often. Just switch your mic. There it is.
Hear me now?
Yep. Yeah, very often, guys, ear pods don't work for speaking. So just whenever I see the little thing sticking out people's ears, I know what to do. Dina, is Holmes right? Is Holmes wrong?
I do not think Holmes is right. I think that the court was right when they said that the law violated the liberty of the teacher, the student, and his parents.
But why can't the state try this experiment? If the state has an interest in promoting assimilation and having a common tongue, why can't they choose this method to accomplish it?
There's no reasonable relation to what they're trying to accomplish. I mean,
Why not? Why is there no reasonable relation? I think there is. Goal is to have people speak more English, and the means is have them speak English at school. That seems a pretty tight fit for me. Pretty good connection.
But speaking a foreign language is not so clearly harmful as to justify that deprivation of rights.
Yeah, but the state thought it was. Why can't we defer to that? Who are we to say? Right? We're not elected. There are a bunch of judges sitting in Washington, D.C. Maybe in Iowa the problem's a little different. It's hard, isn't it? Harrison, you here?
Yeah.
You hear Harrison?
Good morning. Yes.
Who are we to say this is not reasonable? What's that even mean if it's reasonable? Why can't Iowa try this out and see if it works? If it doesn't work, they can repeal the statute. Why should the court come in and stop IO from this prosecution?
I would say that the rights of the individual trump any objective of the state. They even say that a desirable end cannot be promoted by prohibited means, and it's a violation of individual liberty.
How do we know that?
The 14th Amendment.
I've read the 14th Amendment many times. It just says the state shall not deprive a person of life, liberty, or property without due process of law. How do we know? How do we know any of this? Where does a court get this from? It's not like free speech where it says you have the right of free speech or free exercise of religion where there's some text. All we have here is the word liberty. How the heck are judges supposed to know how to decide whether a law is reasonable or not? Whether a law is arbitrary or not? How are we supposed to know? Why can't we why look, I know people like to hate on Holmes, but I'll defend him just for argument's sake. Why can't we simply say, we'll defer to the state, they know better, they have expertise, we're just judges?
In this opinion, it says that the court has attempted to define that, and I mean, I guess it's not written
define
specifically
what?
in the 14th.
You said define that. What's that? Define what?
The liberties guaranteed to the individual.
Okay, so they have this list of liberties, right? That the majority comes up with.
They do, but in the opinion,
right?
The majority
just give me some of them. Just read them for me if you can.
You broke up for a second. What did you say?
I'm sorry?
You're frozen again, Professor.
I'm sorry. I'm sorry, Harrison. The question was, could you just give me some of those liberties that are listed?
Sure. It's without doubt, it denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in the common occupations of life, to acquire useful knowledge, and that was kind of the one that stuck out to me. But to marry, establish a home, bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common.
Okay, thanks, Harrison. All right, so Justice McReynolds, who wrote the majority, comes up with this list of 7 items or so. I think Morgan, are you next? Morgan, you here?
I am. I'm here.
Morgan, where does he come up with this list from? Where does he get this from? We just have the word liberty. Where on earth does Justice McReynolds get this list from? How the hell does he know this? It's a lovely list of things. I like these. Engage in knowledge, marry, all these good things. How on earth does he know any of this?
Well, some of it comes from the Bill of Rights, but also I think some of it comes from unenumerated rights that are just so important to humans that you just can't mess with them, I guess.
Yeah, how the hell do you know that? How do you know that? How do you know any of this?
Just from our human experience and our...
Is there a book I can look to? Is there some sort of statute I can check? How am I supposed to know this?
Sorry, I can't hear you. What did you say?
Is there a book or some sort of statute I can check? How am I as a judge supposed to know what this list of 7 rights is? Where is this written down?
Well, the due process clause.
It just says liberty.
You can't deprive a person of life.
How am I supposed to know what the substance or meaning of liberty is? How am I supposed to know?
So that, because
it's hard, isn't it?
Yeah, I guess if you can kind of balance if you take this liberty that's being questioned, and if, like what you're saying earlier, if the state has a higher interest in it than like your own personal interests, I don't know.
I know. Chris, I see your hands up. Is it you have a question? Chris, hand down.
Yeah.
Yeah, go ahead.
Yeah. Could you possibly make a freedom of speech argument?
Well, you could, but I'm not going to because at this time the free speech clause didn't yet apply to the states. So if you notice, they're not relying on the Bill of Rights. We're still in the 1920s.
Yeah. I was just wondering.
That's fine. I think who's next? Jose, you here? Jose, where does Justice McReynolds get this list from? This list of 7 lovely rights, as opposed to the 7 deadly sins, I suppose. Where are these 7 things from?
I'd have to kind of agree with Morgan that they're unenumerated rights, and I think that's what the court is still trying to figure out today, to add or take away.
Well, then, why isn't Justice Holmes right saying, listen, how are we a judge supposed to know? Maybe the answer is there just are no rights that are unenumerated. If it's not written down, we'll just move on with our lives and just let the people of Iowa decide what to do. Why should the courts get so aggressive when we're dealing with rights that are really, I don't want to say made up, but just, they're not written down anywhere?
I think to summarize what Justice Meyer said, it's kind of fundamental rights that...
What does fundamental mean? That's a word that students love using. What does fundamental mean? Oh, man.
Just... I don't know.
I know.
What he...
I love... okay, Jose, I put you on the spot enough. Look, I love this exercise in this case because it's fairly inconsequential. And I don't mean that, but it's so abstract for you to think about banning teaching of German. Who cares? But imagine the same question posed. How do you know if a right's fundamental with a case that actually matters, involving, abortion or gay marriage or sodomy or whatever else you want as contraception, right? How is a judge supposed to know what rights are protected by the word liberty? And if they're not certain that their rights are protected, how can they tell the democratic process to say you're wrong? Right? These are not easy questions. And the Supreme Court would spend, the last 70 years or so fighting over this question, where the justices vigorously disagree. If you thought the Scalia dissents were angry in the first half of the semester, just you wait. They're livid. They're incensed on this issue of substantive due process. All right, real good discussion. Let me try to summarize. I think I tortured about 15 people on the roll. I apologize. It's like a firing squad going right down the list. When you have these substantive due process cases, you should be asking yourself 2 primary questions, right? The first question is, what is a government trying to achieve? Right? What's their goal or what's their end? And the second question you should ask yourself is, what are the means or the methods they're using to get there, right? What are the means and where are the ends? You've heard the expression that the ends justify the means. That's what we're talking about here, right? Is what they're doing important enough to justify the law, right? Is the interest in assimilation important enough to justify the banning of the teaching of the foreign languages? Here, Justice Holmes is, if nothing else, consistent. He's following his Lochner dissent. And he says, look, this is insane, right? Why are we in the business of making up this right to education, to direct the upbringing of your children's education, and second-guessing Iowa? If they want to ban this, let them ban it. And the majority says, no. There are certain rights that are fundamental. This is what Jose used a minute ago, right? There are certain fundamental rights. There's certain fundamental rights that are so important that they don't need to be written down, right? These are rights long recognized in common law. These rights are essential to the orderly pursuit of happiness by free men. Oh, beautiful prose, right? It's essential to the orderly pursuit. Oh, people keep calling me, right? It's essential to the orderly pursuit of happiness by free men. All right. What does that mean? I think Morgan was hinting at this a minute ago. Actually, I think she got pretty close. It's these sorts of rights that people could not exist without. That if you didn't have these rights, we couldn't function as society. Where does he get these rights from? He kind of looks at history and says, well, these are things that are really important. You know, for example, the right to marry, the right to establish a home and bring up children. Why is that right so important? Well, there's an obvious reason that may not be so obvious to you. If people can't marry and raise children, the species dies, right? Imagine the state passed a law that made it a crime to reproduce. I mean, you think it's insane, but like China has limitations on who can reproduce. If you have too many kids, they not anymore, but they would basically make it a crime to have multiple children in some cases. So it's not insane. So Harlan says if you don't have these rights, our society can't exist. Then you have some rights that resemble the Bill of Rights. I think someone mentioned that also. I think Morgan said that as well. The right to worship God, right? Well, that sounds like free exercise of religion. I think Chris mentioned free speech. That sounds good. But at the time, the First Amendment didn't really restrict the state power. So this is all in the 14th Amendment. Then you have the more kind of odd outliers. You have the right to pursue a contract, or the right to engage in a common occupation. That's to negotiate your labor contracts. Is that as important as marriage or worshiping God? Some may say yes, some may say no. But this list of 7 rights is, made up, right? I mean, it's a good list. It's very pretty. It sounds nice. But where do we get this from? So here, the court recognizes you have these rights and says the means that the government chose here were prohibited, right? There's nothing really harmful about speaking foreign languages. Therefore, the court says the law is arbitrary, right? There's no relationship between promoting assimilation and banning the teaching of languages. I don't know if that's correct. I think if you ban teaching foreign languages, you do help assimilation. But I think what the court's saying is you need to do better. So, maybe instead of banning the teaching of German, you require the teaching of English. I think Moses mentioned this in the notes a few minutes ago. What if you have a test on English proficiency, right? And everyone's required to pass an English proficiency test to graduate. There are different things you could probably do to ensure proficiency in English short of banning of teaching of German. Indeed, in this case, the German was actually being taught as a Bible story, as a Lutheran Bible story. So it wasn't even as a second language. But the majority here was really acting in the model of Lochner, the Lochner majority. And they said the state has to demonstrate why they're doing this, right? Why do you have this law in the first place? And the state failed to meet that burden. They couldn't show that this was a legitimate a law. The reasoning is always very light. It's very fluffy. It's like, well, I think it's unreasonable. It's arbitrary. Right? What does arbitrary mean? Right? You have to kind of get a little creative. Holmes, if nothing else, is always consistent. It's like, no, this is not for us to decide. Let the government decide. Okay. Questions on Myers against Nebraska? I keep saying Myers. It's Meyer. Singular. I'm sorry. There's no S. Any question on Myers? Damn, I did again. Meyer. The reason why is you have United States against Myers, which is or Myers against the United States, which was the postmaster case with removal power. That's why I keep confusing it. All right, let's try the next question, number 5. Let's try the same game again. Short answer. This is for Pierce. What is the state's interest to prevent private schools? Okay, and I think next up is, I think Moses, you're up next. Another 10 seconds. Alrighty. All right, Moses, let's try this out. What is the state's interest here with the banning of the private schools?
Okay, well, my technical problems right now.
That's
so,
okay. You're live. You get the floor.
No, excellent, Dan. Well, we need a uniform, standard way of making sure that all of our kids are educated in society. We don't want nobody to have any differences. We want to make sure that it's perfect, and the only way that it's perfect is if we send everybody to public school.
Okay, good.
And
go ahead. I'm sorry, I didn't mean to interrupt you.
No, that was it.
All right, so now let me ask you the follow-up question then. Right? The state's interest is having, and let me just tweak your answer a little bit, right? My question is, what is the state's interest? And I think you gave me actually both the interest and the means. I just want to separate them out, right? So you said the interest was to ensure that you have students who have a certain base of knowledge, right? That was the end. And what was the means to get there? How are they going to accomplish that?
Everybody has to go to public school at this point.
Okay, good.
This way the state can regulate public school.
Right, okay, good. Right. So I just want everyone to see what I just did there, and I think it's important. Students often merge the means and the ends, right? They sort of combine them. And Moses did, and I think he did it, he gave me a very good answer, but I want to just separate them, right? And the reason why is you can't look at constitutional laws as sort of just this sort of glob where everything comes together. In your head, try to separate what is the government trying to achieve and what are the means using to get there. So in this case, in Pierce, they're trying to create an educated body where all the students have the same amount of knowledge, right? That's their goal. But their means is by shutting down, or actually they don't have to shut it down, but they basically make it a crime to send your kid to a private school, whether religious or secular. It didn't even matter. Erica, I think you're here?
Yes.
Okay, Erica, let me ask you this question, please. What other method could the government have selected to accomplish this same goal?
The first thing my mind came to was like a homeschool kind of, and setting like a uniform education with homeschooling, if that was an option.
Erica, let me ask the question differently. How else could the state ensure that students get an education outside of being in public school? What could perhaps the state do?
Requiring, instead of going to homeschool or instead of going to public school, providing, we do the standardized testing.
Yes. Did you go to a private school growing up, or do you know people went to private school?
No.
Okay. But you know that people in private schools have to pass certain tests, right?
I guess so.
Okay.
The whole state, right?
Yeah, okay. It's an unfair question. I'm sorry. That's fine. Thank you, Erica. Okay, so maybe, right? Maybe instead of banning all private schools, the state just says, fine. If you go to a private school, you have to teach certain topics. You have to meet certain standards. You have to pass certain certification tests, right? You have to do certain things. Lady, is that okay? Is your hands up?
Yes, that's okay. My question was the state's purpose to make sure kids who are maybe being kept at home to help work have the opportunity to go to school, or was their purpose that we want everyone to go to public school, we don't want the private schools?
I think it's the latter. Because you could have compulsory education laws for public or private. Say you're required to send your kids to school, whether it's public or private. Gavin, what do you think?
Well, I mean, on that, like, it didn't show the exact language of the statute, but the way I read it was that they were requiring all kids to go to public school, which implicitly means they can't go to private school. The statute itself didn't say kids can't go to private school. So I think their main intention were that kids were being educated and weren't ditching out on school before 8th grade.
I think that's right. Yeah, thank you, Gavin. So let me just go back to my question before. When we're talking about constitutional law, we have to look at both the means and the ends, right? The means and the ends, and the means that they're using here. The means that they're using here are very extreme. They're far more narrowly tailored methods they could use in this case to avoid shutting down the schools. They could enact compulsory education laws, which says you have to go to some school, any school but some school. They could enact regulations that the private school must cover certain topics. They have to maybe put standardized testing to ensure the kids in private schools are getting a good education. But they went to they went all the way to the extreme. They said, no, screw it. It's a crime to send your kid to a public school. Now, that was Moses, Erica, Jeffrey here.
Yeah.
Now, Jeffrey, this is kind of referenced in the reading, but at the time in the 1920s, what was the most popular type of private school? Just if you could guess.
Catholic.
Yeah, Catholic schools. Why might the state of Oregon have decided to make it a crime to send your kid to Catholic school? Just throwing that out there.
Probably not a big fan of some religion.
No. You're actually understating it. Thanks, Jeffrey. There was a very strong anti-Catholic bias during this time period. It's hard to actually convey how strong this bias is because the Catholics, I'm Jewish, what do I know? But for the most part, Catholics have been accepted to almost every facet of society, right? There are now 6 Catholics, 5 of whom are practicing in the Supreme Court, right? There basically are 6. Well, Gorsuch is unclear exactly what he is, but he's kind of Catholic-ish. His faith is a little bit unclear. But there's at least a majority of the court that are Catholic, right? For the longest time, there was one Catholic that's called the Catholic seat. Justice Butler had it. There was one Catholic in the court. When President Kennedy was elected president, it was a huge deal to have a Catholic president. People thought he'd be loyal to the Pope. There was very strong fears of the Catholics in this period. It doesn't exist today the same way it did then, but I want you to have that history. There was an anti-Catholic bias. This was a way to shut down Catholic schools. They don't have to name them, but they knew by shutting down private schools, they would shut down Catholic schools. Again, this was not based on free exercise of religion because it didn't exist to the First Amendment. This was not part of the state's restrictions. All right. But here, the court says that shutting down all Catholic schools is not reasonable. Right? It's the same analysis as in Meyer, that this law unreasonably interfered with the liberty of parents and guardians to direct the upbringing of their children's education. Okay? So Pierce and Myers are kind of like sequels to each other. They follow very similar reasoning, and they held that the state can't interfere with the upbringing of children in this fashion. It's unreasonable. That maybe the state can regulate the schools, but they can't shut them down. All right. I want to make sure I have time for Buck. Any questions on Pierce. All right. Let's try the next question. This one usually gives it a little of a discussion point for number 6. Multiple choice. Ready for this one? Number 6. Which is a greater deprivation of liberty without due process of law? A. Compulsory sterilization for imbeciles. B. Life-term commitment, that's imprisonment, in sex-segregated prisons. And just to make clear, in both options you can't reproduce. You can't reproduce if you're sterilized, and you can't reproduce if you're in a sex-segregated prison. Don't tell Justice Gorsuch, but at least don't fight the hypo. That was mean. Oh, I'm beating on Gorsuch today. Sorry. And there's no right answer to this question. This is an opinion question, and I framed this question differently over the years, and I get different results. I always try and tweak a little bit. This one I think is a better framing. Look at that. Okay, Mr. Kevin, I think you're up next.
Yes, Professor.
Okay. What's your answer here, sir?
So I kind of followed the logic of the case as well, though. But I did put B, and I mean it's kind of one of those picking from the most horrible answer. Right? So, kind of the idea I went with is if either way this is going to happen to you, in one way you're also being imprisoned.
So in other words, if you can't reproduce, you're better off on the street than locked up in a facility.
Yes, and again, they're both bad. I mean, that's one of those options. C would be my preferred answer.
Yeah, there is no C. Sierra, are you here? Sierra? No? Gavin, you here? I said, yeah, you're here. So you're here earlier. Gavin, what's your answer here, sir?
I said, I can't remember which order they were in, but that it was more wrong to sterilize imbeciles.
So you think it's worse to sterilize a person, a procedure that takes, maybe a few days to heal from, than to lock them up for life?
Yeah, I mean, we still lock people up for life. I mean, but I'd say there's probably an argument that you couldn't sterilize people, like on our own standards to this day.
So, but again, in both cases, you can't reproduce because you're not around people of the opposite sex until Justice Gorsuch, right?
But it's a matter of like the state taking your ability to reproduce versus the state limiting, I guess, your ability to reproduce. You just can't reproduce because you're in jail or you're confined.
Okay. All
versus
right. Gavin, let me ask you a follow-up. Let's say there's a person who's convicted of sex offense, right?
Mm-hmm.
And they're given an option to spend 30 years in prison or to be castrated. Right? Castration is remove their sexual organs. That's what that means, right?
Yeah.
For a guy, for example, right? He's a convicted rapist, make you a child rapist, right? He's given a choice. He can go to jail for 30 years or given an option of castration. Can the state give him that option?
Can the state give him that option?
Yeah.
Sure.
And which option? And you think the sex offender will say, you know what? I'll spend 30 years in prison versus getting a castration. You think you would prefer that option?
I think that would greatly vary because I'm sure there are people that are charged with sexual assault that do try to chemically castrate
No, not chemical. I'm talking old school. It's not chemical castration, actual.
Well, there are people that have done that too.
Yeah. Let's see, maybe one more. Vikesh, what's your answer here?
So I chose the life-term commitment, but my issue with the answer choice is commitment because I feel like it's more of a choice on a person's end.
No. When you're committed, it's involuntary. I'm sorry, just to clear.
Okay.
The phrase commitment means involuntary.
Okay. then I still do think I think, in my opinion, it's B.
Wow. All right. Well, just the results here are 60% thought that the sterilization is the greater burden, and about 40% thought the lifetime commitment. Usually it's about 50-50, so I guess it's a little bit skewed. Maybe we're on Zoom too much. I don't know. The idea of a lifetime commitment doesn't seem so bad when we're all on Zoom all day. It feels like this interminable prison of grids. Tori, you wanna jump in?
Well, just a quick question: are we not supposed to be considering? Because in my head, I'm thinking, well, you're locked up. It's not just your right to reproduce that's at jeopardy there.
Yep.
You're losing a slew of rights at that point.
Yeah.
So I'd be like, snip it out. Give me my freedom.
So you would take the compulsory sterilization over the lifetime commitment?
Yeah, for sure.
Not even a close call of your mind.
I could adopt kittens. That's fine.
Adopt kittens. Okay. Oh, God. You get me canceled. All right. Thank you, Tori. Anyone else? It's somewhat of a personalish question, but I think it does get to the heart of this case, the Buck case. I don't have any kittens. Yeah, Harrison.
Is it not in life-term commitment? Have you not gone through due process of law?
You were given a trial just like Carrie Buck was given a trial.
I don't know. I think I don't see anything about due process of law in A, so that's why I picked A.
No, there's a hearing. There's a trial. You got a hearing. You got a trial. Judge said yes. You were an imbecile. That was the hearing.
Imbecile's kind of an arbitrary standard.
Well, who are you to say what's arbitrary? Why can't the state decide what an imbecile is? Why can't the state decide what the right language to learn is, how to run schools? You see where this goes, right? Who are we to say that bakers have a dangerous profession? You see, it's the same question, right? Who gets to decide? Who gets to decide what the proper interest is? The state or the individual? Lainey, I see your hands up.
I'm just thinking if somebody had a trial and is sentenced to prison, they've done something.
Yeah.
Where Carrie was just born this way. She didn't do anything.
The state thought she was a harm. She posed a danger to others. Her reproductive organs were a threat to the security of the state.
Yeah, I read the notes about her stepdad too. I'm on Carrie's side.
Okay, Matt.
I was someone who chose A, and I chose A because for me, thinking about kind of the violation of someone's person, to do a medical procedure, to me is that extra step that to me feels more like a deprivation of liberty than simply, being incarcerated.
All right. Thank you all. I appreciate the comments. And by the way, I have to confess, there's an error in the book. Lainey mentioned the stepfather. It was actually a cousin who raped her. I made the error in the book, and the stepfather was an asshole also. But it was actually the stepfather's nephew or something that committed the rape. So I screwed up and I apologize. I fixed in the 100 Cases book, but the textbook was published earlier, so I apologize. But thank you for reminding Lainey to make that correction. This is a hard case to teach, and I don't want to make light of it. There was a book published a couple of years ago called Imbeciles. I think the author's name was Cohen. It's a hard book to read. It's not an easy book to read. The reason why this book, or this case, I think is so difficult to teach is because it's so short, right? And Holmes writes with such ruthless precision. He approaches this case as if it was removing a hangnail, right? It's just, it's the procedure at issue. You had a, hangnail removed, right? When we're talking about a woman's reproductive organs in her young age. So let me discuss this case a little bit. And if we need to spill over till next class, we can do that one. But Virginia enacted a couple laws in 1924 that are important. One we'll study now, one we'll study later. The first was the Racial Integrity Act that banned interracial marriage. We'll do the Loving case, Loving versus Virginia, I think next week or so. The court would declare that law unconstitutional in 1968 or 69. I'm blanking on the year. But that same year, the court enacted the Sterilization Act, which said that so-called imbeciles could be sterilized. These two laws were basically part of the same package. The idea that the human race was destined for a bad place, and people could take the fate of humanity into their own hands by genetic engineering. Now, they didn't have, DNA splicing, things we have today. It was much more basic. They thought, well, the way to improve the human race is to control who reproduces. And the undesirables, so to speak, were not allowed to reproduce. So you can't have black and white people producing. That's a no-no. You can't do that. And you can't have imbeciles reproducing because they'll pass on their traits to their children, and they'll create these awful family trees. People often think that Nazi Germany invented, it's called eugenics, right? Nazis did not invent it, they perfected it. It was created right here in the US of A. And this was a very, I don't want to say popular, but it was a very widely held belief system that was accepted in elite circles. You can go to college and major in eugenics. They had PhDs studying this stuff. This was well accepted and well, publicized. So it's not like controversial. But some courts in the early 20th century said, whoa, you can't sterilize a person for being an imbecile. What the hell? You can't do that. That's new. So Virginia said, we need a test case, and they engineered this case. And they found poor Carrie Buck. Poor Carrie Buck. Why do I say poor Carrie Buck? She was picked in very unfortunate circumstances. Her mother had given birth when she wasn't married. What's called wedlock. It's not really a phrase we use anymore, but Carrie was born out of wedlock. Carrie also had a daughter, Vivian, who was also born out of wedlock. And there's some very strong evidence that she became pregnant because of a rape. And again, it wasn't the stepfather; it was I think a cousin or it was a nephew of the stepfather. So I think it was wrong in the book. I apologize for that. After she became pregnant, the stepdad basically sent her to a home, right? This home for epileptics and feeble-minded. The center then picked her to be the sort of test case for sterilization. It was a total setup. Her lawyer was actually a member of the board of the colony, so he was not on her side. He was basically, going through the motions. His entire goal was just to make sure the case moved along well to get to the Supreme Court. That's what their goal was. They didn't want to actually litigate. He had no witnesses, no evidence. Remember I said, you go to court, you present no evidence, say, thank you, Your Honor, we rest. That's basically what happened here. No evidence, no witnesses, nothing. It's not even clear that Carrie understood what was going on. I don't think anyone told her. She may have known, but she probably had no idea what the hell's going on. That's the better one. And then the state had their experts, right? We talk about deferring to experts. What if the state has a law about baking, or the state has a law about learning German, or the state has a law about, I don't know, teaching Catholic schools? They always have experts who say, here's what we think, and what deference do you give? Here the expert said, well, Carrie Buck is part of a line of imbeciles, and there's a family tree. There are 3 generations of imbeciles. The mother, had an STD, and she had birth at wedlock. And the daughter, Carrie, also had birth at wedlock, and she apparently was an imbecile, which wasn't true. She could read and write. She went to high school. I don't think she graduated high school, but she went to high school. She was educated. And then the daughter, poor Vivian, the little girl, less than a year old. I have a daughter now who's now 4 months old, and I've had a 1-year-old daughter. They can't do anything. They don't know what the hell they're doing at that age. They have no idea what the hell's going on in the world. And the idea that you can administer some sort of IQ test to a toddler is just she's adorable, but it's insane. It's just crazy. But that wasn't the goal. The goal was just to run up the statute. And the case goes on appeal to the Supreme Court, and the court affirms her sentence of sterilization. The court upheld Virginia's law. And Holmes wrote this very brutal opinion where he says 3 generations of imbeciles are enough. This is a very famous line. In fact, it was read during the Nuremberg trials. The lawyers for the Nazis tried to demonstrate that eugenics was not just a Nazi problem, it was an American problem. And when the lead lawyers for the Nazis actually read from the Holmes opinion, just to see where this went. Holmes says this was not a challenge to the procedure. In other words, this was not a procedural due process challenge. She had a judge. There was a proper trial. Someone asked about conflict of interest. Oh my God, yeah, there was such conflict of interest here, but just they kind of ignored it. Rather, Holmes says this was a challenge to the substantive law, right? The substantive law. This is Holmes hinting at this distinction between procedural due process, and substantive due process. And Holmes makes a very simple argument. He says, look, if we can lock people up for life, which a state can do, right? If we can lock people up for life, why can't we take the lesser step of just burdening them with a surgery? This was the question I gave you before. If you can be locked up for life where you can't reproduce, why can't the state take the cheaper approach of just sterilizing you and letting you have to go free and running around the world? Holmes writes, the state does not need to wait for the state doesn't have to wait for the degenerate offspring, right? They don't have to wait for people to do this. That's why I put this question to you at the poll. Because if you're favoring lifetime captivity, they think Holmes is wrong. But I think Tory and others said, yeah, just snip, let it go, adopt cats, right? If we adopt cats, then is Holmes so wrong, right? Of course, you say this is insane. This stuff about imbecility is nonsense. It's gibberish. But how does the court know #science what the right answer is? Is it for the legislative process to decide? Right? We're looking at this through the lens of 2020, where we know how science works. But at the time, this was science. This is what state of the art was. Everyone knew this was right. I'm going to go maybe a minute or two over, so if we need to leave at 12:10, that's fine. Holmes also says, look, people have burdens, right? We have a draft where people are sent to war to die. Holmes was a soldier in the Civil War. He was shot twice and survived, right? He survived 2 gun wounds in the Civil War. People don't survive one usually. He says, how can we call on our best men to be to be shot in war? We can't call on these imbeciles to have a minor surgery performed and live their lives normally without reproducing. They're alive. They're not like the people buried in the cemetery at Arlington. All right. The vote in Buck was 8-1. Justice Butler dissented. He was the lone Catholic in the court, and the Catholic Church then, as now, opposes sterilization. He didn't write a dissent, and there's some rumors that of why he didn't write it. There's no good reason. We don't really know why he dissented. I've looked into it. I can't find a good reason. He just dissented. It was fairly common at the time to dissent without an opinion, but, that was that. Okay. I want to do a summary of the cases in a minute, but first I want to give people a chance to ask. Are there any questions on Holmes and the Buck opinion? Yeah, Macy, go ahead.
I know you said you're going to summarize in a minute, but just what do I need to take away from this? Because the case is so obviously misguided that I'm not sure what I need to take away from the opinion.
I'll get there. That's my goal in 1 minute, I promise. Okay. But questions about the Holmes opinion in general? All right.
Well, Professor,
go ahead. Who's talking now?
Sorry, this is still good law, apparently.
Who's talking now?
Mike Cooper.
Mike, I'll get there in 1 minute, Mike. I promise. Any question on the analysis itself, not its impact today? All right. All right. We've done now 7. Okay. So we've done 7 due process cases in the early 20th century. Some of them are good law, some of them aren't. Okay. So first off, Lochner is not good law. Atkins versus Children's Hospital of D.C., not good law. Both of those cases follow the Peckham model, where you put the burden on the government on economic cases. The Supreme Court has said, no, you cannot do that. Eventually, Justice Holmes' opinion, his dissent in both cases prevailed. So for Lochner and Atkins, the majorities are not good law. The Holmes dissents in both cases are really the standard now for economic cases. Then we have Meyer and Pierce. These are good law, but in a sort of quirky fashion. Myers was about, teaching Bible stories, and Pierce was about, Catholic schools. Today, the court views Myers and Pierce as First Amendment cases about free speech and free exercise of religion. That was not how they're written, and you just read them. You know that's the case. They don't even mention the First Amendment. But the Supreme Court in the 1960s, I like to say, laundered the opinions. They sort of just rewrote them and said, no, these are about First Amendment. Why? That argument allowed them to keep Myers and Pierce, but get rid of Lochner and Atkins, right? They say, well, Lochner and Atkins are about personal liberties, but these are First Amendment cases, so they're safe, right? So they sort of morphed these old substantive due process cases about children in schools, which are, fine, people like them, to First Amendment cases. All right. Third, we have our good friend Meyer. This was a case about women working so many hours. If you remember, the Brandeis brief argued that women were these inferior vessels of children and they can't do anything else. Only slightly exaggerated. So Meyer was based on this sort of rampant sexism. But today, Meyer is considered a good case, not about the gender discrimination, but about the deference, that we should be more deferential to the state when we're reviewing these regulations. We studied Buchanan v. Warley, which was about the segregationist order in Louisville, Kentucky. Again, that was an economic liberty case, like Lochner's, about the right of contract. That case has been basically rewritten as a equal protection case, that you can't discriminate against people on the basis of race. That's not how Buchanan was argued, because at the time, Plessy was still good law, right? Plessy was the rule. But if you look at cases like Brown and some of the other cases, they cite Buchanan as evidence that you can't discriminate on the basis of race. Then we come to the last case, Buck v. Bell. And I can give an even more robust answer this semester than I would in the past. Buck was never overruled. Never overruled. Indeed, it gets favorably cited in some unexpected places. The place where it gets cited most controversially is in Roe v. Wade. Most case books edit that part out. Randy's did. I put it back in because I thought it was important. And I'll explain why it's cited. We'll study Roe in a few weeks, but Roe, people things to say that women has a right to with her body she chooses, right? If she wants to terminate a pregnancy, she can terminate the pregnancy. Not so fast, says Roe. Roe explains that people do not have the right to do with their body what they wish. It's unlimited. The state has an interest in your body, and if the state decides you should stay pregnant, you should stay pregnant. And what's the citation for that? Buck v. Bell. In other words, if the state can forcibly make you sterile, the court says, they can also make you remain pregnant. So it's a weird rule in Roe that this is cited, and most people just don't know they exist. I always make a point because it's people ask me, is Buck still good law? Well, kind of it is. There are also cases every now and then about chemical castration. I think Lainey mentioned that earlier, or it was Gavin. I think both did actually. And there's questions of whether a person can opt into chemical castration as a way of being released early, right? That's a condition of release. And you better believe it, those cases cite Buck. So it's a sort of case where like you realize like, how can this possibly be, good law? But I think it reflects the sort of deference that Holmes preached. And it's still out there. And during the discussions of the pandemic, we're talking about mandatory vaccinations. The line of cases from Buck becomes relevant, right? Can the state forcibly sterilize you? Can the state forcibly vaccinate you? Holmes says, look, if we can jam a needle in your arm and make you take an unsafe vaccine, why can't we remove your organs? Oh, yeah, maybe one's permanent, one's not. But if the way to stop the spread of smallpox is through a vaccination, you do it. If the way to stop the spread of imbecility is sterilization, you do it. Keep in mind, they viewed imbecility as a disease, and the way to stop it was through sterilizing these people. There was no birth control. Contraception didn't exist. That was a thing back then. If it did, it wasn't very effective. The way to stop it was by sterilizing. Okay. I think I'm done. I said I went a few minutes over. I apologize. I'll start the minute poll now so you can get going on that. Are there any questions from the students? And I'll be here in office hours. It's going to be 10 or 15 minutes. I'll be back, I promise. Have any questions before we wrap up? No? Okay. And again, the link for the transcript is here. If you click that link, maybe in 15 or 20 minutes, it should be indexed by speaker with audio. It's pretty cool, but I'll take a look at it later. All right. Thank you very much, everyone, and I'll see you later.